Without me, you have a quorum. 1, 2, 3.
There's enough. There's enough.
Yeah. I can sit down there and watch y'all.
Why would we?
Cause I can look at you. How's your wife doing? Are you gonna bring her to the Rotary banquet?
Think so. Yeah.
Good. I think you should.
Yeah.
If not, I'm gonna make trouble for you. No.
And for a while I was not, then I sat.
That this Saturday? I think so, I forget. God,
I'm just
Until
creeped
the
up
last
on
minute, and then
well, I'm not wearing a
chair,
dress.
the chair would call order, and then.
Yeah, now you have quorum. I don't have to.
And then you could,
It moved me.
and then you could leave.
So comfortable.
There won't be a full, couldn't go. And you don't know.
Hi, how you doing this evening? I'm good, thanks.
Basically, I am the board attorney.
I will be, go ahead and. Remember what they, is it the ceiling, is that what they changed here?
I've never had.
Good question. I have no idea.
Very nice young man.
Whoever the attorney was, that first time I was on the board, I haven't been angry. And they get the
I was expecting a neighborhood of women here tonight. Maybe that's not happening. A neighborhood of women are gonna come in and complain about us, approving the Stamus boat storage.
Either one.
A long time ago.
I like you
But
too.
they were in the neighborhood all complaining and gathering, that they were coming in. Yeah, that's what my neighbor said who lives there, and said, you know,
Yeah,
like
I
them
know.
tonight. And I said, okay, well, they're not here, so that's a good thing. Maybe next time.
Complaining to us won't do them
No,
any good.
no, it doesn't do any good.
No, if they wanna complain, I guess, to the city council, I guess it could be done.
Mr. Chairman, you do have a quorum. The first time
Yes.
since I've been on the board, so I'm just gonna back out.
Okay. Yes, we do have a
That's
quorum.
too late,
Thank you,
but-
Anita.
Yeah.
I'll just sit down there and look at y'all.
She's been there a lot longer.
You're welcome to do that.
Just smile big.
It's nice that we have a quorum.
It is, it's the first time since I've been on this board
That
as
there's
an
been enough-
alternate that
that
you've
there's been
got a
enough
quorum, yeah. No,
But there's been enough people for her not to sit at the, by.
Oh.
all right. Yeah, this is exciting. This is really a 4th of July event.
If it's not a full board, you don't sit, then I'll have to be.
Good evening, ladies and gentlemen. It's 7:00 p.m. City Hall of Tarpon Springs. This is the Planning and Zoning Board for our June 20th, 2016 meeting. And we'll begin with a roll call.
Mr. Vinson,
Here.
Mr. Carr,
Here.
Mr. Parker,
Here.
Mr. Gialosis, Ms. St. Arnold,
Here.
Mr. Seaman,
Here.
Mr. Haas,
Here.
Ms. Protos.
Here,
We have a quorum, and so we'll begin. The next item on the agenda is the quasi-judicial announcement and the swearing in of speakers. If you do plan to speak, be sure that when it's called that you stand up, raise your right hand, and be administered the oath. Our city attorney will do the announcement.
This is a quasi-judicial proceeding where the Planning and Zoning Board acts in a quasi-judicial rather than a legislative capacity. At a quasi-judicial hearing, it is not the board's function to make law, but rather to apply law that has already been established. In a quasi-judicial hearing, the board is required by law to make findings of fact based upon the evidence presented at the hearing and apply those findings of fact to previously established criteria contained in the Code of Ordinances in order to make a legal decision regarding the application before it. The board may only consider evidence at this hearing that the law considers competent, substantial, and relevant to the issues. If the competent, substantial, and relevant evidence at the hearing demonstrates that the applicant has met the criteria established in the Code of Ordinance, then the board is required by law to find in favor of the applicant. By the same token, if the competent, substantial, and relevant evidence at the hearing demonstrates that the applicant has failed to meet the criteria established in the Code of Ordinance, then the board is required by law to find against the applicant. Are there any, is there anyone that is wishing to speak this evening? Please stand and raise your right hand. Do you swear affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Thank you very much. The next item on the agenda is the only application we're hearing tonight. It's application number 16-34. It's a site plan for Denami Holdings LLC, and it's a request to approve a site plan for a phased project consisting of boat slant RV storage, office, and warehouse uses. And we'll begin with the staff report.
Thank you and good evening. Okay, this project is located at 240 Anclot Road. It consists of 9.77 acres that are currently zoned industrial restrictive with the future land use of IL, or that's industrial limited. This applicant came before you in 2013 and before the Board of Commissioners in 2013 requesting approval for this same project. At that time, they were given approval for the first 5 phases of the project. The first 4 phases of the project. However, they were unable to construct. There's a requirement in your land development code that an applicant come forward unless they request through a new phasing schedule that's approved by this board and the BOC to have an exemption from this, that they actually get their first building permit, which usually tends to be the site work for the site, the locations of, drive aisles and that type of thing. In this particular case, the first building wasn't going to go in the first phase anyway. It wasn't going to be to several phases later. It was going to be an open storage to concept to start. So the applicant did not come forward, and they were not aware that they had to come forward and get that building permit within the set 1-year time frame. So as a result, they came to me last year and said, well, we never got an approval letter. And that may very well be, but the condition still stands. And unfortunately, it had been more than the 1-year time frame. Our code does allow for a 6-month extension for them to come back to the process and ask this board and the Board of Commissioners for a 6-month extension. But their site plan had completely expired. So they have to request that within 30 days before the expiration date. They could not do that. So at that point, I basically said, okay, well, we have to go back through the process. Is there any changes that need to be made, that type of thing? And they indicated that the one change that they wanted to ask for was really the phasing schedule. They still are on board with the fact that they recognize they must get that first building permit within a 1-year time frame. Now that they're aware of that, they're going to move forward. However, they've asked for, rather than having each phase approved per year, they've asked for an overall 5-year phasing schedule that allows them to go out. So any one phase, if it's not finished in each year, they would have up to that 5-year window. If there's any changes or modifications during that period, they would still have to come back through this board and through BOC for approval for any changes, but it would allow for them to have a little bit more flexibility between the phases. Certainly, if you look at their site plan, their drainage that's shown on the plan is a phased drainage plan. And they had talked, their engineer is not here today, but we had talked with their engineer to find out, what was your intention with the phased drainage. And he said, well, really why I want the flexibility is if they decide to advance a building, I want to make sure that all of the things that need to be in place, the fire flows, any of the utilities for that building and the drainage are in place prior to that building going in. So as a result, we would make sure he would do that anyways through the building permit process. But as a result of that, he asked for that flexibility. So that's really the change that has gone on in this. They did submit for their Swift Mud permit. They were issued a Swift Mud permit. The particular phases, and they have an environmental analysis that's part of your packet. That environmental analysis for phase 5 through 6, which is the back portion of the property, that is where the endangered species are. They have some gopher tortoises in that area. At the time that they come back through the process, they will need to do an updated analysis. We are actually asking you, and I'll go over the conditions that we're going to ask for, but we're actually asking for them to update that analysis because it has been a good 2 years since that, or 3 years since that analysis was evaluated. So we want to make sure that gopher tortoises haven't moved anywhere else on the site where they weren't previously. But other than that, there has not been substantial changes to this property with the exception of that phasing. So I just wanted to get that out there so you clearly understand where we're at. The staff report you have before you is very similar to the staff report that was proposed by Rodney Chapman when he was here in support of this project, with the exception of the phasing schedule is slightly different. And with that, we had a TRC meeting. At that TRC meeting, what we really discussed was the changes, if they were going to make changes to the project. What I indicated that we needed was whatever they were going to propose for a phasing schedule, so that this board could look at it and determine whether or not it's appropriate or not. There were some questions basically from the building department that they need to meet the building code and the city landscaping code, that they need to make a temporary 16-foot driveway width, and that's actually for one of the farther phases along. They'll need to have a temporary driveway width so that they can turn the fire apparatus around in there to provide for adequate room. And with that, the utilities are available to the site. They have not changed at this point. The access is going to be limited to 2 vehicular access points along Anclot Road. The parking for the site plan exceeds the requirement for 1 space for 1,500 square feet of gross floor area required for off-street parking. The landscaping and screening plan is consistent. We will ask for, and we're going to have to amend the conditions here slightly. We will ask for an updated tree survey so that we can compare any growth that has happened or any changes that are happened on site or to conditions of trees or that type of thing at the time of the building permit. So we'll include that in the conditions that we're going to require. Sidewalks will be constructed along the roadway. There are no current right-of-way issues. There's no fire protection issues. We've already talked about the environmental assessment, that we're going to want an updated environmental assessment. They will be required to, during that assessment process, to identify any required permits, and those permits will need to be obtained during the permit process. Based on this, the level of service standards have not changed, and they are consistent with the existing level of service that's available in your comprehensive plan. We have no objections in providing a certificate of concurrency determination for this particular project. And with that, staff is recommending approval of the site plan for phases 1 through 4, subject to the following conditions. And there'll be a small change on 3 that I'll read into the record here. The developer is responsible for acquiring all other jurisdictional permits and meeting the minimum criteria of the Land Development Code. The site plan shall expire within the 1 year of the effective date unless an application has been filed for a building permit. Prior to the site plan approval, an updated environmental assessment and tree assessment must be submitted to the Planning and Zoning Department. Fire lines required for the proposed buildings and sewerage lift station with appurtenances and services for the RV washdown area shall be installed as part of the Phase 2 construction. Utility service lines and fire lines for buildings 3 and 4 shall be installed as part of Phase 3. At that time, the fire line installed in Phase 2 will be tied into the new fire line, creating a loop system. The loop system is what is required under the Florida Fire Code. City staff reserves the right to require a new site plan if there are major changes to the codes and/or regulations. The architecture of the buildings must be substantially similar to the renderings submitted by the applicant. The applicant must demonstrate that lighting is unobtrusive to adjacent property owners or vehicles on Anclot Road, and the site plan shall expire within 5 years if phases 1 through 4 are not complete. And with that, I can answer any questions that you might have.
Thank you. Okay, questions for staff at this time?
I have a couple.
Okay.
One, if the site plan shall expire in 5 years, what if 1 and 4 are not complete? What happens? They're Phase 2 and they're not complete.
If they're at Phase 2, they'd have to come back through this board to ask for Phase 3 and 4 to be approved again. And then if they want to go on to Phase 5 and 6 and 7, then they could ask for at the same time for those to continue.
Okay. The second question is about the lighting, and must be unobtrusive. So does that mean that that's also the new lights now? I think standards are that they don't shine upward.
Correct. They would need to be shielded, and we can change the language here if you want to get a little bit more specific in the type of obstruction that light might penetrate. You could get into talking about they are required to provide shielded light fixtures or something like that if you want to do that. This is leaving that open to the applicant to provide and propose a plan for proving that any light that is spilling off of that property is in fact unobtrusive to adjacent property owners and to traffic along the roadway.
Okay, and then there was also one about the environmental with the animals, endangered species that are on the property. So we're asking them now to do another assessment of that?
Correct, because it's been a number of years, and like any species, turtles tend to move, as this board is well aware. So being that gopher tortoises have been spotted on the rear portion of the property, even though they're not asking for approval at this time, we need to make sure that they do an updated study to make sure that there are no burrows that have moved to a different part of the property. And while I appreciate the applicant, these can be kind of expensive. This is a species of concern that the state has really kind of cracked down on the types of permits and stuff. They want to have good studies. So we want to provide that availability to the state.
But they'll have to move them regardless of where they are.
Correct. They'll have to get a relocation permit, but we want to make sure that if the relocation permit is now required in one of these phases that wasn't required in any of these phases previously because they weren't impacted. They weren't impacted because they're on the back part of the property where phase 5, 6, and 7 are going to be. So as a result, we just want to make sure that they didn't move into phase 1 through 4 at this point, and now a jurisdictional permit's required by the state. So we're going to ask them to update that study, provide that information to us so that we can determine that, because if that's the case, when we get to the building permit process, we want to ensure that they get that state permit.
Okay, so as it is, then if these animals have moved and we don't put that in, then they could actually just come in and just develop this land, even though we have in there that they have to move these animals if they're on the property?
Well, I agree that we do have them. There's kind of a redundancy because we do tell them they have to meet the land development code, but being that your staff has been such a revolving door here, I want to make sure that these are tight, these requirements that you have on applications, that the applicants are things, so it's clear if new staff comes in here, this is what we required. We've had some real issues with not having really clarified conditions in the past as a result, and then we have new staff come in and they don't necessarily know the same thing that the previous staff does. It's very difficult sometimes to get all of the background for some of these projects, and as a result, we want to make sure that we have tight approvals that, one, we can defend, but also that are very explicit so the applicant knows what their responsibilities are. And I wanted to make that the applicant, I want to put them on notice because they've already had an issue with this project not moving forward. We want to do everything in our power to make it so that they know what they have to do to move forward and be successful with the development of this project.
This condition 3, where it says prior to site plan approval, are we not, or maybe I'm a little confused, are we not approving the first phases of the site plan tonight? So are we requiring them to submit that before the approval we would potentially give tonight is finalized, or is this talking about prior to site plan approval for the other portion of the
It
property?
probably should read building permit approval, being that there is a site plan that's part of that process, so it will probably just make it clarify and just put building permit approval.
Okay.
So that new condition would read the building permit site. Let me get to the right one. Prior to building permit approval, an updated environmental assessment and tree assessment must be submitted to the Planning and Zoning Department. That will cover that, and that makes it clear.
That makes sense, yeah.
Okay, we can do that.
I have a question.
Ms. Podus?
2, maybe 3.
Okay.
I went out there, and I think you're gonna have some granddaddy rattlesnakes out there too.
Yeah.
They're
It's,
not endangered, I don't think.
I know there will be.
Are they endangered?
No, they're endangered to me. I was just looking at the area, I says, oh, well. In this area photo, and then we have another one here, where this is going, it's next to Grove Avenue. Are they gonna have a buffer for some of these houses?
Yes, there will be a requirement for a buffer. Now, it is a very limited buffer, but there is also retention area on that side, so it's gonna
Okay.
provide a little bit more distance than what your code only allows for limited buffering requirements, at least the distancing criteria. They have to be planted, obviously, with plantings, but the distance between the actual project or the back of a building and that property line is only about 8 feet in your code currently. So as a result, they're also gonna have drainage retention areas on that side, so you'll have a little bit more space. And again, those drainage retention areas have to be planted as well as the buffer has to be
And they
planted.
have to have a fence around them.
That's correct. They'll have a fence to protect,
Yeah.
in this case, to protect the type of use that you have there. You don't want to have people getting into RVs and that type of thing and causing any kind of damage.
The other question is, and I've read through this, but explain to me, they're not right on the water. So if people have their boat in storage and they call up and say, I want my boat taken out of storage because I want to come and get it, where are they going to take these boats to get them into the water, or get them out of the water to take them to the storage?
It's not like a boat and storage club like Stamus's yacht does. It's not that type of system or dry storage.
Okay, I want
What
that
is
explained
what's
so
and the
people can
applicant can
hear.
explain this further. But what it is it's basically like a self-store type thing. You bring your boat there and you rent a space for your
Okay.
boat or your RV. But the applicant can speak to that a little bit more about how he's planning that to happen.
Okay, very good. That's what I wanted to hear because of traffic there. But he has met every requirement,
That is correct.
and he has paid and he's done everything he's supposed to do to be here tonight to get the approval.
That's correct. I mean, he's got an active Swift Mud permit. The only question that we really have is I really just want that environmental updated, so I
And I
know
wanna
that
thank
if
you for that.
I know if a Gopher tourist permit is actually required or not. I don't want that to be a surprise to us.
I want to thank you for that because that's very important for Tarpon. Okay.
I have a couple questions also.
Sure.
I noticed that the foliage only goes along I believe, the east side of the property and not on the north side of the property too, where there's residential houses. I think there's some trees that are left in, some live oaks and stuff for existing foliage blockage. And then it doesn't look like it runs down the whole east side of the property for the additional phases. I think it stops about 3/4 of the way through. So I'm just wondering what our code really says about that. Are you familiar with that and what's required?
We get to full build out.
It's like one of the last pages in the packet.
The full build out. Sorry, let me get to the full build out.
The last page.
Said north side, right?
East side.
Said north side, east side.
Good, wasn't it?
It's east side is where it showed that the wax myrtles are going in, but the north side, and it doesn't go all the way down to the east side. I think there's a 50-foot buffer at that point. But the north side, where there's some residential properties there also, I think it shows a 20-foot buffer, but it doesn't really say, it doesn't show there's going to be additional plantings of like shrubs. I think there's just existing trees that are there.
They're required to meet, it doesn't matter what size buffer they provide, like you have a minimum that you have to provide. Obviously, they have to provide what they show on the plans, but they will have to put plantings in where there are not plantings and prove to us that if there are gaps in that they are filling the plantings. They do not, if they're using native vegetation that's existing there, as long as it provides an 80% opacity, then that's what your code requires, is an 80% opacity
Can
by
you
6 months.
explain that to me?
That's when the shrubs within 6 months to a year grow, they have to grow up to a level where at your level when you're standing, they are thick enough that they are basically opaque, where it's 80% of that is filled in. Now there may be some gaps that over time will grow in. It's not a full 100% visibility barrier, but it's meant to be a barrier between the adjacent property, so that they're not looking at directly into gaps in that thing. So 80% is not 100%, but it's 20% less than 100%. So it's meant to be a full buffer and full growth within that 6 month window, 6 month to a year window. And a lot of it depends on the plants that you choose. Some things are faster growing here in Florida. They will have to do irrigation. Some things are slower growing. So if you choose some of those faster growing plants, they'll get up in 6 months versus some of the slower plants will be up within a year. Now, if you're using native species and if you're using existing vegetation, you fill those gaps that you need, that you have between you and that type of thing. But if you've got 20 foot versus 8 foot, you require an 8 foot wide buffer. Those plantings can be spaced out a little bit different. So they will tend to stagger those plantings in a little bit different pattern than they do when they just use an 8 foot because it's a narrower buffer.
I don't know if we have to be concerned about the question I'm going to ask tonight.
Okay.
That isn't a flood zone.
That's correct.
All right, and is he talking to you yet or anybody about what is going to happen, what he has to do to provide protection on the flood zone?
He has not talked to us specifically about flood zones and the type of issues. Those become an issue when he actually gets to constructing buildings, and at that time, the building department will require him to meet the flood zone standards that are in effect at that time. Which why that matters is our building department is ever changing, and they're trying to reduce our overall exposure as a community. As a result, they'll be instilling different regulations over time to try to drive down those costs in our overall flood insurance rating for the entire community. As they do it, those changes will be made. So we don't want to lock them in at this particular time to a flood standard that 2 years, 3 years from now is slightly different. We want them, when they come in to permit, to be consistent with the regulations of the day.
Very good. Well, knowing the gentleman, of course, I haven't talked to him about this, but I know of his business, other business dealings. He's very astute and very on top of everything that he does. And I didn't read too much about the flooding, and that's why I asked. And I know that he'll go the extra step to make sure it's going to be what it's supposed to be.
Yeah, if it needs to be elevated, right now he'll elevate it up to the flood elevation plus 1 foot of freeboard, once they go above 1 foot above. But that could change over time. We may decide as a community want 2 or 3 foot of freeboard. If that changes, we want to be able to hold this applicant to that. And we actually have a condition that would let us do that anyway. As a community, we put a condition in here that says at any time, if our regulations change, we want to be able to ask for a new site plan, especially on a phased project. So we've protected ourselves, but at this point, having them dealing with flood zones is a little premature because the buildings aren't coming in until we get into much later phases.
But I want to congratulate you. The amount of backup that you gave us is phenomenal compared to years past. And you really did your homework on this, and it was very instrumental for us. So thank you for all the work you did on this to give us an insight so we can make a good decision.
You're very welcome.
I have a question about the number 8 condition on the obtrusive light. I remember when this came before us a few years ago, and at that time we really didn't have any ordinances applying to outdoor lighting. Mm-hmm. And do we now have ordinances? I'm not aware of that, but
No, we don't have ordinances. Basically, what I have done, I gave you basically the base that you had previously approved with a few changes based on the things that have changed that I really needed to address here or clarify. This is something that you've seen on some of the other ones that I've had is asked for shielded lighting that is directed internal to the site. And if you would like to do something like that, we can certainly change this condition. I'm not holding to this condition. I'd like to hear from the applicant and make sure that he's all right with that change. But if you want something like that, at this point, we do not have a requirement for lighting plans and that type of thing. They need to prove it by showing me that the fixtures work. I look at the general fixture, I determine the foot candles and that type of thing, what it throws, where it's located, and that type of stuff. And I hold them to these conditions. If there's an issue, we send code enforcement out there. And if there is, in fact, an issue or a complaint, that complaint is taken seriously.
I think it was about this time, and I'm the one that raised this, I believe, when it was before us a few years ago. And after that time, we, I think, had a consensus on the board to request the city to consider a comprehensive outdoor lighting ordinance.
It's on my list.
And I know I communicated that, and I appreciate that. But that's why the wording here is just sort of, we were just going by the seat of our pants at the time.
Do you want to is the consensus of the board that you want to change that? You want to change that? What I could suggest is the applicant must demonstrate, or the applicant must provide shielded lighting that is directed internal to the project.
Yeah.
Is that
Yes, and
sufficient?
can you limit it to skyward as well, so that it doesn't
Okay.
shine upward
The
any more
applicant-
than the buildings?
Must provide
I don't think that adds any extra cost to the lighting.
shielded
Just
lighting.
more protection.
What's the matter?
And we
And-
do want to protect the vehicles driving along there, and I
Protect
think that was one of my concerns
being-
a few years ago, is that the driving down Anclote Road, not at this, there's one project down there where
Yeah.
the outdoor lighting shines right in the eyes of the driver coming down if you're heading
Can I just put another thing in there?
heading west,
No
near
overly-
Port Tarpon, before you get to Port Tarpon, right along that stretch. It just shines right in your eyes, and you're blinded. And so it's really a hazard on the
Chairman
road.
Vincent, it was upwardly directed light, is that what you wanted to say? I'm gonna put a second provision, is that what you had said?
Wanted to limit the upward direction, so there's not upwardly
Okay.
directed, at least beyond the roof line or the, of the buildings, or something to that
Applicant
effect.
Must provide shielded lighting, limiting upward light and directing lighting internal to project. So this is what I've got. Make sure that everyone's okay with this. The applicant must provide shielded lighting, limit upward light and direct light internal to the project.
Okay, does that include, do we need to specifically say anything about the roadway or the vehicles? Or is that implied there if it's
I would say that
internal?
that's implied there, but it's completely up to you. If you want something else, we could add another portion to that condition about Anclote Road, that the light be restricted, and prevented from spilling into the roadway.
Wouldn't there be a state ordinance about it, or a state rule about that?
Unfortunately, no. Lighting is one of those local, it's
Right on
it's
the
one of
street.
those things that it's a local issue. If
State
you,
DOT is the worst character, or worst.
yeah, they are not a good actor when it comes
Okay.
to
Well, then-
that. So,
Do we need to
You can
add
see our-
that then? Yeah.
Look at the satellite photos.
right, so the applicant must provide shielded lighting, limit upward light, and direct lighting internal to the project, light must be directed away from, Anclote.
It's Anclote, by the way, I believe.
Okay.
You're sort of new here in town, but Anclote is the way we pronounce it. At
Road.
least the old
Sorry
timers
about
pronounce
that.
it that way. I don't know how the others do.
Sounds like the GPS.
All right, so this is what I've got for the condition. It's kind of like a two-part condition. Applicant must provide shielded lighting, limit upward light, and direct light internal to the project. Light must be directed away from Anclote Road.
Surprised no
Like
one's
a
touched on
cloat.
that. Okay, yes.
Are we good?
Yes,
Has
that's
everybody
good.
got all the parts they need?
Right.
Okay,
Happy.
all right.
Any other questions for staff?
Yeah, I'm sorry. I just wanted a couple clarifications. And so the shrubbery only goes along the east side, really, not all the way down. So I don't know when we address that, but it's not in the back part of the property, and it's not in the west side. But I'm not sure if there's no residential property over there. I'm not really sure what the code says for undeveloped land, or whether that could be in the future. But there's no buffer in the front of the building. Also, it's just a fence and grass. So can you help address that a little
Yeah,
bit?
they will have to provide buffering outside of any trees that they already have there. They will have to provide buffering that is consistent with the perimeter buffering sections. So if the plantings aren't specifically shown at this particular time, when they come in with their full plans, they will need to show us that.
Isn't that what these are, though? They're full plan?
Well, they will be a little bit more, when the building permit plans come in, they're a little bit more clear on exactly how the plantings are laid out and specific to what plantings. So if you want to provide them here, we can either tell the applicant he needs to come back with a updated landscaping plan, or we can provide additional conditions.
Okay.
A related comment then too is does the landscape plan adequately address the tree replacement requirements that goes, because a substantial number of trees of pretty good size being removed? Does that plan address that, or are we relying on the building permit set to make sure that those replacements are called for? Because I'm just a little bit concerned that by leaving it as loose as it could be at this point, that we might be giving the idea that we're approving something that's not really fully approved if we don't make that very clear, I guess.
Well, we are requiring them to provide us an updated tree assessment so that we can evaluate any changes to the trees. If it's the board's desire to have them do that now and delay this project so that they can do that, we certainly can do that. But we have provided a condition for them to provide that information. I'm confident that the applicant will provide that information at the time of building permit, and they will allow us the time to send out the tree, the certified arborist. So if there is any questions on, the old plan versus the new plan and the sizing of those trees, to ensure that if there has been any tree growth, any significant tree growth, it's accounted for. But the applicant will be required to meet the mitigation requirements in the code, which are actually more substantial than when he was approved, because you updated your code in 2015. He is now bound by your 2015 code, which is part of the reason why we're asking for that updated assessment. So if it's the purview of the board that you would like to delay the project to have them provide that analysis, we can certainly do that. But at this time, their application is complete, at least by staff's analysis. If you want to provide additional requirements for them to provide buffering and or planting schedules or that information, we certainly can ask the applicant to do that. That's up to this board.
I think my only concern with it is just to make 100% sure that it's very clear to everybody that by approving this, we're not saying the landscape plan as it stands is adequate to meet all those requirements.
You'll be able to speak in just a few minutes. The staff has done its report, and we're asking the staff about that. And the next item on that, it would be the applicant.
Probably.
Thank you, sir. It'll be just a few moments.
Well, again, it's up to this board. If you feel that that you need a full landscape drawings and that you don't have sufficient approvals with the conditions, we certainly can delay the project. That's completely up to this board.
But you're gonna send somebody out to make sure it's carried through anyway, and what
Yeah,
is there
I'm
and
going to
what is
send
not.
this. I'm going to send the arborist out there with the existing plan and with the updated plan and say, okay, I would need you to verify that this updated plan is in fact the updated plan that meets today's code, because those mitigation requirements have substantially changed.
I would think we could trust what he comes back with.
Yeah, there's a lot of even laurel oaks in that property that are old. So, they could even died off since 3 years. So it could even be less trees on there than what was out there 3 years ago.
That's why we need a comparison study, I think, is the most appropriate way to deal with this.
I've got a question too. There's a automatic gate in the front. That's a 20-foot setback off the road. It shows. My kind of thought process. I don't know if you've ever driven down the road before, but people tend to speed down the road tremendously, and if you have a boat you're pulling, a boat might be 20 feet or so. A truck's another, 16 feet. So we're looking at 36 feet. So you have the tail end of the boat hanging out into the road while someone's waiting for an automatic fence to open, while people speed also down that road, and it creates a blind. It creates a blind opportunity for someone to go around the boat while another vehicle is coming down the road. So, do we have anything that requires a certain setback off roads with gated, automatic gates or something along those lines? Is that
gate is, for this particular type of development, no, that's something that we require when we look at subdivision. It's something that it's not specific to this type of standard. It's not a bad suggestion in this case. A decel lane and that type of thing is not warranted based on the type of traffic that's expected for the project. Unfortunately, that would be ideal if there was enough right-of-way to provide that decel lane so folks are off the actual right road. But it's not a bad idea to talk to the applicant, see what the applicant's feeling is, possibly push that gate back a little bit up onto the property to allow for a little bit more room to come in. And we can ask the applicant that question if you'd like.
I know that issue was discussed a few years ago, and this was before us, and I think at that point, the entrance gate was recessed or offset some distance to
Yeah, that's
accommodate that.
where it's at now, but what Jacob's saying is maybe it needs to go a little bit farther than what that was previously approved, and I don't necessarily disagree with that, because you are talking about trailer and boat
Yeah.
connected, or
If it's
car
a
and boat
50-foot RV,
connected.
or if it's a 25-foot boat, or whatever it's gonna be hanging out.
And we
so.
can talk to the applicant and get his
Fine. Yeah.
opinion on that.
Because I think it was moved.
Because it never, the code was never changed. If the question is, was the code changed? No, the code was not changed.
Any other questions for the staff at this time?
Yeah.
All right, we'll hear from the applicant at this time, sir. When you come to the podium, please state your name and address.
Nick Mavramatis, 213 High Street, Tarpon Springs.
Thank you, sir. Do you want to go ahead and maybe start with any opening statement about what you've already heard? Apparently, you want to respond to something, you feel free to do that now.
That's why I was asking if you can ask the questions again. I don't remember it all. But the only things that I was hearing is some of the things that I think y'all are asking about or questioning. It sounded to me like they weren't part of the current ordinances or codes or whatever we're calling them. And if they aren't, how can we be held to a different standard? That's all I'm saying, as far as that's concerned.
Mm-hmm.
The gentleman that mentioned about the access, the setback's 20 feet from the property line, is that correct? Mm-hmm. So that's at least another 10 feet from the edge of the roadway, because there's the ditches out front. There's grass, ditch, and then more grass to the property line. So there's a bit of a buffer in there already. If you drive down the road there, you'll probably notice it. There's an open ditch and grass on both sides of the ditch. Our current property line's probably about, I'd say, 6 feet or more back from the inner edge of the ditch on the north side of Anclote Road. So we've got about, I'm gonna guess you probably got about 30 feet to the gate now, roughly now, I haven't measured it. So you've got a bit of a buffer there too. To move that gate back too far, it's gonna kinda change, I think, everything internally as well. I don't know. But, so we have a little bit more than just the 20-foot setback. That's a setback from our property line, not the roadway.
You could move the north one slightly in, but you're gonna lose parking if they move the southern or the lower location. They'd actually end up probably losing 2 or 3 parking spaces for when they get into their final build out for this building D. So they'd have to accommodate, to do that, they'd have to accommodate the additional parking elsewhere on the site that they're gonna lose by adding that driveway, that gate there, because you can't have the parking outside of the gate. That doesn't help.
That's not gonna be RV parking most likely, though, or boat parking. That's gonna be like
The parking that you have here by Building D is actual parking for Building D to serve the uses that are going to be in
Right.
Building D.
yeah, so
So,
it's like office or warehouse or something.
yeah, whatever workshop area they end up doing.
One of the other things I was gonna ask about, and listening to you folks, was there again this lighting situation. I think, like one of the gentlemen said, it came up before, and they said that, we can't have any light. And I know which light you're talking about on Anclote Road. I go down it all the time and I see it. It was said that we couldn't have any light that's gonna affect the traffic, adversely affect the traffic.
Which is kind of like what they have for this this particular thing. They're just tightening down. They're holding you to shielded lighting for the internal to the site. No fixture that allows light to go upward.
What does that mean, shining up
In the sky, in the
Shine up
sky.
directly in the
You
sky.
know where the birds are and the airplanes.
Oh,
versus if it's
The
shielded.
bats.
I don't know why anybody wanna waste their money and shine lighting up the
But
sky,
yeah,
but,
and
okay.
then just that those fixtures that you do have are directed internal to the site, and then the final thing was that light must not be directed, it must be directed away from the road. So
Right.
it can't be directed into the roadway now.
Yeah.
That doesn't mean that you can't have lighting at your entrance, because obviously we want it to be safe, and people are gonna be punching in codes, so we want that to be safe. But we don't want it being obtrusive, into the roadway where it's basically lit up like,
There's
Fourth of
quite a bit
July.
of lighting out there now. I don't know if you went out there at night. We have quite a few lights out there, because we have a lot of equipment parked there right now, and we've had some instances of people, coming in the back trying to steal things that they too heavy to carry off, so they left them in the woods. But so there's quite a bit of light now, and it's just like typical, like what are they, Cobra headlights? Is that what they call them? The street lights. And I don't think you'll find any of those. The ones along the front of the property are really facing, kind of in, so they don't. And it would be something similar to
So
that.
it sounds like you're meeting that condition already, Nick.
Yeah, it's lit up very well out there at night. I mean, it is.
So I think he's satisfying that condition, so as long as you continue that through the rest of the development, there shouldn't be an issue.
Yeah, I say that typically in the past, most industrial lighting has been open, like most street lights have been open on the top as well as all the way around. And that's, I think there was just a study not too long ago said 85% of our stars have disappeared because of all the lights that shines up, and we lose that. So, I think we have to start someplace to start getting that back.
Like I say, personally, I wouldn't take this the wrong way, but I wouldn't waste the money shooting the light up.
Yeah.
The idea is to put it down to light the
Right.
area on the ground. I mean, off the ground. Those are really the only points that jumped out at me. That's why I was asking about some of the questions, if they were going to be asked of me again.
Well, Nick, the other question that the board has got some concerns is about your buffers and whether they're going to be, whether they'll be planted. I mean, I'm going to have to hold you to the planting schedules in minimum in the land development code for the adjacent portions of the property.
Isn't that, Heather, part of it? It's not in the, to get the.
Those
permit, we
have
can't
not
get it.
changed since you came through the process. So the landscaping plan itself is consistent based on what this board approved previously. The only question that we have is really the tree survey, because trees do
Right.
change, just like the Gopher tortoise issue changes. So, and we knew that was something that we were going to have to update going through the process. And it's been 2 years. It's actually been 3 years since a lot of the work has been done for this. But he is correct that the landscaping requirements for landscaping along the front and perimeter have not changed in the code in the last 3 years since he came before this board.
If
So
there's no, it just only shows shrubs across the partly of the east side, so, I don't know if that was overlooked on the last time or what happened, but.
it is possible that it was overlooked at the last time, but it's something that we can draw attention to. I mean, it's completely up to this board if you want to delay the project and ask for an updated landscaping plan. That's completely at this board's discretion. I would say if you're going to do that, then you might as well ask for the tree survey and evaluate the trees at the same time. They kind of go hand in glove. But that's something that's up to this board.
But doesn't that usually come at this time?
The tree survey would normally come at this time, but this is a unique project in that it's been previously approved, and we were pretty confident with the requirements that we've put in for additional conditions that we'll get what we need from them, and we can approve that at the time of building permit, which is when we set their mitigation amounts and that type of thing. I mean, as you're aware, the applicant has some time and some flexibility in our code to determine how they're going to mitigate. They have 3 different options on mitigation, and that's not really determined until you get to the actual physical building permit. It gives them that time to have that discussion and determine if they want to pay a fee in lieu, if they want to mitigate on site, if they want to mitigate off site, if they have additional property elsewhere in the city.
Well, I don't think we should delay his project.
Don't either.
He's heard what we're asking, and
The
I'm sure
north-
he'll come across. I don't want to delay someone's project because financially it's very difficult today to do that.
Let me just say, you mentioned the north property line. The north property line's Anclote Road. No, I'm sorry, I'm backwards.
That's south.
That part, I don't know what it shows back there for, you mentioned the, what do you call it, the mitigation, I don't know what you called it. But isn't that phase 5 and 7, Heather?
That
So 5 and 7, oops,
There goes my thingy. That's okay. It's not important. That's the later phases of the project. at this point. He'll have to actually come back and provide any additional buffering that's required. That's also the area where the gopher tortoises, he's not wrong, where the gopher tortoises will, have to be relocated from or to or whatever, however the state requires him to do what he's gotta do for the gopher tortoises.
Then the west property side, the west line is, as you're, I'm sure all aware, is just forest. I mean, it's just woods, there's nothing there. I don't know. And I think from what Heather said, that's my understanding too, when it actually comes time for permitting, we have to meet the code. You know, if it says you have to have so many trees, you take out this, you gotta put in that. If we don't do that, then we don't get our permit, right? Correct?
That's correct.
So, I
And
mean,
with-
that's kind of
And with the
already,
drainage retention areas that are here, because the drainage retention areas are slid up right against the line, they wouldn't be required to do full buffering along that. Basically, what it says for the drainage retention areas is it's 20% plantings for the 20% plantings along that entire area. So even though technically you would need a buffer along the property line, because you have the drainage retention areas, they're handled a little bit differently. And so the requirements for how dense the plantings have to be are different for them because of the way the drainage has to function. Like the way the slopes and that type of thing are, you can only do so much planting on the top slope before it becomes a burden to the overall function of the pond. So, I mean, that's also, that the other thing is, because you have that open retention area, you're actually providing a wider buffer area than what's required with that 8-foot perimeter buffering. Because the pond is at least 50 foot wide in the widest spots.
for whatever it's worth too, also on that gate, comment, there was a boat storage place there before, but it was just, you know, I don't know if obviously, it was just an open field, and they stored a lot of boats in there. And I don't think there was ever an issue there, but now there weren't, I can't say about RVs coming in and out. But there again, with an electric gate, I mean, the gate's open before you get, you know, before you get there. But there was boat storage there before for many years. So, we're just trying to do it the right way, you know, to go through permitting and do what we want to do. So, I don't know if there's any other questions. I don't think I have any.
I've got a question. There's a couple things I'm somewhat concerned about. Is that you have, it looks like a crushed concrete down the middle on both sides of building A, B, and C, and then that goes in the grass, and then it looks like it goes into a parking pad. Is the covered boat and RV storage spaces, what is that material going to be under the covered area?
I'm pretty sure it's the crushed concrete, I believe.
Because it goes from crushed concrete to grass, and then it doesn't, I'm not sure what the under the covered part is, but I would just think that would be a concern from a standpoint of a business owner, that if you have crushed concrete, it's going to be really a dusty situation with all your clients.
Well, it won't be, there's a couple of different types of that concrete. The finer stuff, the smaller crushed, is very dusty.
Yeah.
But the bigger rock is not. And that's what we would use, because exactly what you just said. Nobody wants someone driving by and dust swirling all over their $400,000 RV. You know, they wouldn't be parked there long. So, yeah, it's the larger gravel, and actually that's something I brought up with the architect on that. And I said, you know, what about the dust? And he said, you use the bigger sized chunks of concrete, and rocks, I guess they are. They're not little pebbles and a bunch of powder in there.
Right. So I guess the question then is, you're going to have the crushed concrete under the building overhangs, and then
That's my understanding. I mean, I don't know specifically. If I tell you
okay.
for sure, I don't know.
Well, I was just thinking, looking at it, you go from crushed concrete to potentially grass, it shows in the design, to crushed concrete or concrete under the overhang.
Where are you
I
seeing?
actually think that it might be grass under the buildings, and I'll tell you the reason why. Because it's grass all adjacent to, once you come off the crushed concrete drive, it looks like it's a grass area there, and it would make more sense, obviously, if you're going from the concrete to the crushed concrete to the grass, that you would maintain that grass surface underneath the building.
What's the concern?
Yeah, but
Well-
how can we ask that?
The issue is that grass doesn't grow in the shade. is one issue, and then secondly is that when you put an RV or a boat over it, grass won't grow into that too. So then you're gonna have a sand pit. So if people are trying to pull their trucks out or RVs out, and there's
Well, here's the thing, if I have a problem with it, we'll fix it, because nobody's gonna wanna park there. You know, obviously, we can't put something we can't park on, and those vehicles are pretty heavy. So it has to be, you know, something stable under there.
that's all I'm trying to make a
Yeah,
point of
of course,
about is
yeah,
that
I mean,
it shows
that-
that there's grass, but
And I don't
I mean,
know.
I'm guessing it's grass, I don't
I mean, does
really
that make
know.
sense? What I'm
Yeah, no,
does-
it's
it
a,
does
it's a
make
legitimate
sense.
question, because all you see is concrete to grass to building, but you don't know what the surface is under the building.
For whatever it's worth, right now, I drive tractor trailers out there on that grass. I mean, big, heavy equipment. And haven't never gotten stuck once, you know, and that's without doing anything, any kind of developing to it. That's just the native grass that's growing out there in the field, in the front portion. The back portion, as you know, is all woods.
But wouldn't it
I've never even
eventually-
been back there, quite frankly.
Wouldn't it eventually cause a problem? What is that block stuff that the grass grows through, the holes in
Oh,
it?
Yeah, but I don't think.
That
Turf
for road-
block.
what is it?
I think you're talking about turf block.
Yeah, they use that a lot for road area and for parking.
Yeah, I don't know, but whatever it is, it'll have to be, we have to address it to make it attractive to potential customers to park there and be able to get in and out easily, safely, and without any problems, so I don't see that being an issue.
your other parking spots along the retention ponds, 1B and 1A, they're all grass too. So, I mean, it's up to you as a business owner. But if I was in your shoes, I think I may look at some alternatives to materials for safety and the aspect
One
of
B
getting
and
stuck.
one A,
So
is that?
that's on the east side where.
Oh, that's the boat storage, the trailer and boat storage, yeah, that grass would be fine.
Yeah.
That won't be a problem with that.
Any other questions for the applicant from the board? Sir, do you have any other comments you wish to make?
No, I don't, not that I can, not that I remember, to be honest with you, but I think we've covered most of it.
Okay, thank you very much, sir.
Thank you.
At this time, we'll hear from the audience or the public at this time, either for or against the application. Seeing none, we'll close the public portion of the hearing. And now the board will entertain a motion and then discussion on the motion.
I make a motion that we, okay, application number 16-34, is it Denami Holdings, with the recommendations from staff that were changed.
Second.
There's motion and second to approve the application with the conditions as stated and as modified by staff. Any discussion on the motion?
Yeah, I have a question for the city planner. So when he comes for the permitting, then it's going to be, although it's not, the landscape isn't necessarily designed up to potentially what it should be, they would be held to what the actual permits are, requirements by the city to fulfill the buffer that's needed.
That's correct for phase 1 through 4. Phase 5, 6, and 7, which is the back part of that property, they won't be required to do anything to it. When actually we'll tell them you can't do it. It's outside their project limits. So they will be held to on those first phases. Now, if we change our requirements again, they will have to meet them for the later phases. And that goes for the project as a whole.
Right.
If phase 1 comes in and we do an amendment, a drastic amendment that changes anything in the code that applies to this, they will have to meet those changes. This does not give them, this site plan approval does not give them a one-way ticket out of the land development code just because they've met the majority of the regulations at this time. If they change, that's why we put that condition, that first condition in, that they have to get all jurisdictional permits and meet all the land development code requirements. So if we change them, they're subject to whatever changes we make.
Thanks.
Any other comments?
Yes, in planning, could we as a board ask that we look into, what'd you call that block stuff I asked about?
Turf block?
Turf block instead of broken concrete and stuff like that. Could we make it to where that's what they would have to use if they didn't want to put down cement pads or an asphalt road to go in and out? I don't know if other communities do that, but I think it would be neater looking and easier to take care of.
It also adds tremendous cost.
I guess we ask the attorney or ask the board, do we have a right to ask that?
If you, what Anita's trying to get to is, can we change the code to require those things? Now, you can recommend to the Board of Commissioners that they look at the alternative surface section that they already allow, because they allow alternative surfaces. Broken gravel or broken concrete's one of those alternative surfaces. Shell is certainly one of those alternative surfaces. Mulch is one of those alternative surfaces. There's a whole slew of different ones that you can look at. You can certainly recommend that as a board to, we can bring that forward as a potential amendment to the code, but right now, the way it stands is the city engineer actually makes the determination on whether the surface that they're proposing is appropriate and is acceptable to the city.
And it is at this time. I just look for neatness and maintenance. That's all.
If we had that power, there'd be a lot of things I'd like to change in town.
I know.
Ms. Protus, I think,
I don't know anything about the materials, sir. I've just seen it in shopping centers and in developments before, and I know it's very neat.
right now, we're discussing the motion. That would be appropriate in comments discussing future action by the board.
Thank you very much.
Any other comments on the motion from any of the board members? Okay, we'll take a roll call vote.
Ms. Protos?
Yes.
Mr. Haas?
Yes?
Mr. Seaman?
Yes.
Ms. St. Arnold?
Yes.
Mr. Parker?
Yes.
Mr. Carr?
Yes.
Mr. Vincent?
Yes,
Congratulations.
it's approved with those conditions. Thank you, sir, very much.
Good luck.
The next item on the agenda is staff comments.
I have one super very happy comment, because I'm a super happy, very excited person. I'd like to introduce this board to my new principal planner, Lisa, if you'd like to stand up. Lisa is coming to us from Ocala, if you'd like to come to the podium so you can speak. She's coming to us from Ocala. She started last week, and we're very excited to have her here and welcome here. I wanted her to get a chance to meet this board, because when I came on, I didn't get that privilege, so welcome, Lisa.
Does that mean you're leaving?
Welcome.
Very nice to meet y'all. I look forward to working with you.
You're gonna love Tarpon.
Lisa,
I already do.
You're free to say a few things about your background or anything else you want to say this time.
I'm coming to you from Marion County. I was a senior planner there and did a lot of code reform for them. And prior to that, I was in the city of Corpus Christi, Texas, where I was the zoning ordinance administrator and their senior urban planner. So I did a lot of urban planning there, in addition to being in charge of the zoning department. And prior to that, I worked with Florida Fish and Wildlife as their protected species permitting biologist. So if you have any gopher tortoise questions, I'm your girl. And before that, I worked with St. Lucie County as a senior planner and with the city of Deltona as an associate planner.
Well, welcome.
Thank you.
Tarpon's a little tough community.
We look forward to working with you.
And you won't stay skinny in Tarpon Spring.
Oh, no. I have to work on that one.
It's got a lot of good places, beautiful places.
Thank you very much, Lisa.
Thank you.
Any other staff comments?
No, that's all that I had.
All right, the next item on the agenda is board comments.
It was exciting tonight.
Are you leaving already?
No.
Okay.
Picking up my, picking this one up, just holding my hat.
Okay.
You want these?
Yeah, anybody who does not want to take their plans with them, you're welcome to leave them for us, and we'll pass them along to BOC so we don't have to kill any more trees.
It is the first day of summer, and I guess it's also in the ancient days known as Midsummer's Eve, so be careful. And don't get too carried away with your dancing around the oak trees. There's nothing coming before us. It's time for adjournment. Is there a motion to adjourn?
So moved.
Second.
All in favor?
Aye.
Aye. Thank you. We conclude at 8:02 p.m. Thank you.
I am the board attorney.
Okay, you're new.
Where's this gavel?
What was it?
The board, I suppose.
What?
You want these?
I so want
can't be on two.
Look at that. We have enough copies now to go to board. I do not have to
The moon
pinch a
tonight,
tree.
supposed to be that orange.
Oh, nice, thank you.
Incredibly bright. Last night, I woke up and thought the sun was coming up, and it was only 2.
Actually, you know, I don't usually give him plans. I only give him, I only do them for the,
As a
if
catch
it's
for a
such
while.
low, I don't think that they need.
Oh, low tide. Super low, which means super high too. So when
Yeah,
it comes
that's
to-
all right.
You live on the water table.
Everyone have a nice 4th of July.
I just do that standard. I'm used to a larger one.
Will
There's
do.
usually a much larger. Oh, God, I hope not say.
Yeah, I live on the end. Yeah, it's
Oh, yeah.
full moon and it's low.
Yeah, have a good night.
Yes,
Thank you, everybody. You are very welcome. Thank you for coming in. And you were number 7 today, so like it was legit, you could still stay there.
Well, you tell my buddy, if he had been here, it would be the first time we've had a full
I
board
know.
in years.
I'm gonna have to tell him. Well, in another couple of months, we're gonna update, the clerk is in the process of updating everybody's, what's gonna be everybody's repent